time to check in with CoinDesk Global Policy and Regulation Managing Editor Nick Day, who is also the editor of CoinDesk, the State of Crypto newsletter. Good morning, Nick. So, what are you looking ahead to?
Good morning. Yeah, 2021 was a weird year. Next year, I think I'm going to be looking forward to whether or not we actually get some kind of firm regulatory agenda from Congress, whether that includes stablecoin regulations or addressing many of the other needs that we've seen folks like acting CFTC Chair Rostin Benham and SEC Chair Gary Gensler refer to. So, whether or not Congress will address the question of is there and should there be a federal regulator for digital assets. Also going to see whether or not we start getting to some of these investigations and SEC actions against startups moving into more of a actual trial phase. So, for example, this year we were talking about the SEC case against Ripple at the beginning of the year, and that's really kind of just been in this administrative procedure phase for most of the year. It's been attorneys kind of filing back and forth, trying to limit discovery or expand discovery, trying to subpoena some individuals or not subpoena them. So we haven't really gotten to the substantive part of the actual trial of whether or not Ripple sold XRP as an unregistered security. And I think we're getting close to the point where we might actually start seeing answers to that question, or at least start seeing the parties try to address that question in a court of law in the coming year.
So, Nick, speaking of stablecoin regulators and regulations and stablecoin issuers, our very good friend Do Kwon has countersued the SEC, or has sued the SEC, saying that there was some procedural issues, et cetera. Can you go into that? What exactly happened there?
Yeah, so this one's getting a little complicated from like a court's perspective. So what happened is, according to a bunch of legal filings that were excellently reported by our colleague Shan, in May, the SEC began investigating TerraForm Labs, Do Kwon, and the Mirror Protocol. And they tried speaking to Do Kwon and other members of the team voluntarily. And at some point, for whatever reason, they decided they needed to issue subpoenas instead. And that led to the infamous mainnet incident that we've been, all keeping an eye on, where Do Kwon was served a subpoena at mainnet by someone at the SEC or by someone the SEC contracted. And after that, Do Kwon and TerraForm actually sued the SEC, claiming, they were out of line, they were out of their jurisdiction, things like that. The SEC filed a separate filing. So it wasn't a response to the TerraForm filing. It was their own, kind of process, petitioning a court to require Do Kwon and TerraForm to respond to the subpoenas that they've already issued. And that brings us to last week, when TerraForm and Do Kwon filed a response to the SEC saying basically they were out of their jurisdiction. The subpoenas were, out of line, unnecessary. And now the SEC has a chance to respond not only to the allegations from last Friday, but the original TerraForm / Do Kwon suit from a month or two ago.
Yeah, he's also claiming that the SEC has no jurisdiction because he's based in Asia, so I hear.
Yeah, that's part of it. The claim is that Do Kwon and TerraForm Labs do not, conduct business in the U.S. and therefore they're out of the U.S. jurisdiction. The SEC's claim is that they are because you can use the Mirror Protocol if you're in the U.S.